Judgment in the appeal, RFC 2012 plc and the Advocate General for Scotland.
Lord Hodge will explain the judgment of the court.
This appeal concerns a tax avoidance scheme and raises an important question about the nature of income tax on the earnings of employees. For many years, income tax has been levied on the remuneration which employers pay their employees, and national insurance contributions, which I'll call NICs, have been demanded on that remuneration. If the remuneration takes the form of money or is capable of being converted into money, it is treated as earnings and falls within the tax charge. Remuneration which is not payable until a particular event happens in the future may not be subject to tax until that event occurs. For example, if an employer promises to pay an employee a loyalty bonus in 5 years' time if he works for the firm during that period, and the employer sets aside funds for that purpose, the employee will not be taxed on that sum as earnings until it is paid on the occurrence of the contingency. The question in this appeal is whether parts of the employee's remuneration, which were given to trustees under a tax avoidance scheme, fall to be treated as the employee's earnings. In summary, the facts are as follows. Companies within the Murray Group of companies, which included Rangers Football Club plc, which I will refer to as RFC, sought to pay their senior employees and footballers large salaries or bonuses without incurring liability to pay income tax or NICs on significant parts of their remuneration. When RFC recruited footballers, a senior executive of the company negotiated with the footballer or his agent to agree a net sum which would be available to the footballer as his remuneration. The scheme involved part of that sum being paid under a contract of employment and recorded in the company's payroll, and the company paid income tax and NICs on that part. The other part was governed by a side letter, which the company did not disclose, by which the company undertook first to pay large sums into a trust, which was called the Remuneration Trust, and secondly, to request the trustee company that it set up a subtrust for the benefit of members of the family of the footballer and transfer money to that subtrust. The trustee company had a discretion what to do, but the scheme envisaged that it would carry out the shared wishes of the employer and the employee. In the event, the trustee did so in every case. The subtrust in each case empowered the footballer to nominate and, if he wished, to change the members of his family who would benefit from the subtrust, and, as protector of that subtrust, he could also change the trustee of that subtrust. It was envisaged that the footballer would be able to borrow the entire sum settled on the subtrust, and that he would not have to pay interest on that sum until the loan was repaid. In all but one case, the footballer chose to take out loans of the funds of the subtrust. The scheme envisaged that the loans, which were for 10 years, would be renewed so that they did not have to be paid and repaid until the employee died, when the loans and the accrued interest would be a debt on his estate, thus reducing its value for the purpose of inheritance tax. Thus, the scheme was designed to give the employee the use of the money, which was the property of the subtrust, and a mechanism by which he could reduce his estate's exposure to inheritance tax. HM Revenue and Customs Commissioners, I will call HMRC, considered that the sums which were paid to the Remuneration Trust were earnings liable to tax under the pay-as-you-earn system, PAYE, and that the employing company should have deducted both income tax and NICs before paying the net sums to the trustee. HMRC assessed RFC and the other Murray companies which had used the scheme to pay bonuses to senior employees on this basis. The employing companies appealed to the first-tier tribunal, which allowed their appeal. That decision was upheld by the upper tribunal, but HMRC succeeded in their appeal to the inner house of the Court of Session in Scotland. RFC 212 plc which is now the name of the former owners of the Rangers Football Club, and is in liquidation, appeals to this court against the decision of the Inner House. This court, in a unanimous judgment, dismisses their appeal. The court makes 3 points about statutory interpretation. First, provisions in the tax code which impose specific charges do not necessarily exclude a more general charge to tax. Secondly, the court must pay close attention to the actual words of the statute and not be distracted by judicial statements which use different words to explain its application in other contexts. And thirdly, the court must adopt a purposive approach to the interpretation of the taxing statutes. The provisions of the Principal Acts and the subordinate legislation which govern the taxation of earnings do not require that those earnings are paid to the employee. If they are paid with his agreement to his spouse, his aunt, or a trustee, they may remain taxable earnings. There is no rationale for excluding from the tax charge a payment to a third party made with the agreement or acquiescence of the employee. Under the tax avoidance scheme, the payments to the trustee of the remuneration trust were made to give benefit to the employee and his family. The payments were not gratuities or incidental benefits in kind, what used to be called perquisites, made to acquire a benefit in kind which would be taxed under the Benefits Code. Nor were they made to confer a benefit only on the occurrence of a contingency in future. Therefore, the general rule that the tax charge on earnings falls to be levied on the employee's remuneration for his work, whether paid to the employee or a third party, is the rule that governs this case. The theoretical risk that the trustee might not set up a subtrust or give a loan of the subtrust funds to the footballer does not alter the nature of the payments made to the trustee for the employee's benefit. Because the sums paid into the remuneration trust were earnings and subject to tax as such, the provisions of the tax code which deem the benefit of loans to be earnings do not apply. The employing companies should have deducted income tax under the PAY system and also NICs, and they are liable to HMRC as a result. The appeal is dismissed.
The court is now adjourned.